07 PL 96. For the record, would everyone identify themselves and who they're representing?
Good morning, Your Honor. Yes, Sean Kenyon with Hefner, Wagner, and Evans, here on behalf of Albany, Indiana, LP, both as the defendant as well as the assignee for Rhodes Plumbing. Also with me today from our office is Mike Meyer.
Okay, good morning.
Attorney Michael Rapp.
Okay, yes, sir.
Drywall Service Injury, Coax Group, Home Valley Landscaping, and H2O Ground Irrigation.
Okay, we're here on a motion for summary judgment. Are we ready to proceed?
And Your Honor.
Okay.
First, Your Honor, as I indicated in this case, Aldi is both a defendant and a plaintiff for the assignee Rhodes Plumbing. However, the motion is best viewed as being filed on behalf of Aldi, the defendant. And in an effort to ensure that we go about this in the way that makes the most sense for the court's time, I'd like to begin by saying that, just so that you understand, Mr. Rapp is not here to oppose the motion. So I'm not sure how much you want to
There's no one opposing the motion. Well, I'm here anyway. We just follow the order.
Well, I'm not on the other side of the motion.
Oh, who's on the other side of the motion? Anybody?
The motion was filed against Covenant Building Corporation.
Did they respond?
Yes, they did not. At one time they were represented in this case by counsel. They are currently unrepresented.
Were they properly served with the motion? Was counsel in the case when the motion was filed?
Their counsel has been out now, I want to say we're getting into years.
And when was the motion filed?
The motion was filed on June 18 of this year.
Okay, and do we have proof of service on the defendant?
We served them at the address that we had. We sent them the motion initially when it was filed. When the hearing was set by the court and we got notice of the hearing, we also sent that to the Smedekers and Covenant. We do not have signed green cards back, however, none of the regular U.S. mail to the address that we had has ever come back, either with regard to this motion, notice of the hearing, or anything else that we've sent to that address over the last many months.
What is this motion to withdraw summary judgment?
That was filed, that's not related to this motion.
Okay, that's something else.
Mr. Lance Snedeker, who is the son and the treasurer of Covenant, as well as the son of the owner, Eric, that was a motion filed on his behalf by his counsel. He is represented.
Okay. So this would be against, which defendants is this exactly against?
His was against all of you.
All right.
That would be Lance Snedeker's motion.
Your motion. Who is your motion?
Our motion is against Covenant, the entity that Mr. Lance Snedeker was treasurer for, his father president, and also against his father, Eric.
So this would be against Eric. And what about Curly Masonry, Nelson Construction, Stephen Ironworks?
No, Your Honor, they are not implicated by...
What is this about here?
The background of the whole case is that Covenant Building Corporation was hired by Aldi to to serve as the general contractor, project manager for a store that Aldi was building in St. John. Construction began, and Covenant continued to submit to Aldi its applications for payment periodically as the construction continued, so that the material men, suppliers, and subcontractors would be paid, each time representing that it had properly distributed the previous payment from Aldi to the subcontractors that had done the work. Well, it turned out that was not true. And what happened ultimately, and that's why the caption is so long, all of these
filed mechanics liens.
The tradespeople filed mechanics liens, or then filed to foreclose on their mechanics liens, or breach of contract because they had not been paid.
Okay.
And now Aldi, of course, has gone back against Covenant and Eric Snedeker. Our allegations, and at this point the evidence has set forth in our motion borne out the fact that the representations that they paid the subs were not true. Mr. Eric Snedeker, in fact, diverted money for his own personal use and to other jobs that were not.
What's this company? Is this company still an entity now? Are they still in business?
Covenant is not in business.
Well, my only issue is, not since the attorney has withdrawn, so we served these people directly.
Yes, sir. In fact, we tried to contact the attorney who had withdrawn that law firm.
Who was the attorney?
It was Elizabeth Cohen and David Krebs at Hostetler in Kowalik, Indianapolis.
My only issue is service. My only issue would be service. If we know we got served, or I mean, once an attorney withdraws, what's the rule as far as service? I know that pretty much, if a pro se enters a case, they give his address. It's just like an attorney. They don't. It's that. But when an attorney withdraws, no longer accepts service, then what do we do? Is it certified mail? Is it simple mailing? I tend to think you're probably right.
And as I indicated, we did that on 2 occasions with regards to our motion.
Okay. Why don't we do this? Just to avoid him possibly coming back with a motion to vacate the judgment, why don't we set it for something along the lines of a order to appear, file, make certified mail him, or get him served somehow, and if he doesn't appear, we'll go ahead and enter the judgment.
Would you like us to prepare an order?
Yes.
We will do that.
Prepare an order and coordinate a date that's agreeable to all of you, and we'll serve it on him. He doesn't appear, you all don't even have to come in. Just one of you come in and go ahead and do the order.
That's what we'll do with that.
Okay, just because what you're going to see is that he's going to file a motion, set it aside. I wasn't served, blah, blah, blah.
Oh my God, that's what.
Okay?
Thank you.
Thank Anything else?
There's a housekeeping error.
Yes.
And this is with regard to the last motion to amend the complaint. Here's the status of this. My firm, my prior law firm, we were representing all the plaintiffs on the court. And so backdrop of there's that Fluence Plumbing settled there.
Right.
And they assigned their interests to all. Now, what happened in the meantime was that the two attorneys from the prior firm that had been handling this, Willie Marcus and Mark Johnson, they had filed a third amendment complaint in 2012. On the side of the and I don't know if the court actually had ever ruled on a motion for a third amendment complaint. What the court at one point said to file explanations as far as seemingly some conflicting positions as far as why it is that you're filing a third amendment complaint when Aldi was not in the case anymore. I don't know. There was a substitution of Aldi with Rose at that point as well. And the gist of the third amendment complaint was simply bringing in two additional claims, H2O and Foam Valley.
Okay.
Substantive issues. I suppose what could have happened was these parties could have intervened as intervening complainants. Instead, what happened was simply a full-blown third amendment complaint proposed to add them in as additional claimants. And that, unfortunately, though, is that's been in limbo then for the last about a year and a half, maybe longer. I would just like to try to get an entry of an order, I can propose an order, simply showing that that's been entered.
Okay.
I don't know if anybody has to file an answer to it. It just reflects the...
Do you have any problem with that?
Okay. Just try to put a record on that.
Go ahead. That'd be fine. Okay. Is that all then? All right, thank you.
Judge, we have a 10 o'clock.
Oh, good.
I called the petition 3 times on